Big
We're going to
changes are
discuss
coming
the
for
new
marriage-based green
2025
cards in
green card rules,
2025 under Trump, and if you're
specifically
not
the big
prepared, your
changes for
application could
married
be
couples.
denied. From mandatory interviews to surprise home visits, stricter financial checks, and longer processing times, the rules are tougher than ever. If you're married to a US citizen or permanent resident, this could affect your entire future. Don't risk a delay or worse, a rejection because you didn't know what changed. Stick around, because I'm breaking down everything you need to know before you file. Let's cut to the chase. One of the biggest changes is the end of interview waivers. Under Biden, many straightforward marriage green card cases sailed through with paperwork alone, but that's now gone. As of 2025, everyone will be required to attend an in-person interview. No exceptions. That means even couples with perfect documentation and long-standing marriages now must show up and answer questions face-to-face. For many applicants, especially those who rely on translators, are from different cultures, or just feel anxious about official questioning, this is a stressful hurdle. But the interview is just the start. To support your application, you'll need significantly stronger evidence than before. Think fully joint financial records, leases and mortgages, shared utility bills, travel itineraries, photos from throughout your relationship, and more. You have to show a life lived together with documentation, emails, text logs, co-signed leases, joint accounts. It all matters more now. If anything is missing or inconsistent, you could get stuck in a requests for evidence, RFE, loop, or worse, face a denial. If that sounds intense, it is, and it gets more intrusive. Home visits are making a comeback. USIS agents might show up without warning to your residence, especially if your marriage is less than 2 years old. These visits are meant to verify your living situation in person, but for many couples, it feels like an invasion, a scenario that can scare even legitimate applicants. But the scrutiny doesn't stop there. The public charge rule, which had previously made it tougher for anyone using certain public benefits, is returning in harsher form. If you or your spouse have used Medicaid, SNAP, or other government support, that could be used against your application. You'll need to fill out the I-864 affidavit and possibly prove that you plus any joint sponsors are financially self-sufficient. Expect rigorous reviews of your income, savings, debts, and assets. The updated Form I-485 now demands even more detail: household finances, benefit usage, education, employment certifications, all in one place. And guess what? No more bill consolidation. You must pay separately for each form or your application could be outright rejected. Now here's something that's shaking up the system even more: processing times are stretching dramatically. What used to be 10-14 months under previous administrations could now stretch beyond 20-24 months. Why? With mandatory interviews for all, increased RFEs, and additional verification steps, and without expanded staff, USIS and consular posts simply don't have the capacity. That means longer waits, greater uncertainty, and serious planning headaches for families. On top of that, the Trump administration is moving away from family reunification toward a merit and investment-driven model. Projects like capping green cards for adult children or siblings of U.S. citizens, as well as eliminating parent visas, are on the agenda. The so-called Gold Card program offers permanent residency, not just a green card, to ultra-wealthy investors who can pay roughly $5 million. This program bypasses existing tracking and job creation requirements tied to the EB-5 visa, privileging financial contribution above family ties. So while high net worth individuals might find a new fast lane, everyday couples face a labyrinth of new hurdles instead. And these changes aren't just about marriage green cards. They're part of a broader shift in immigration policy. For instance, deportation grounds have expanded. Minor misdemeanor convictions, extended time outside the U.S., or failure to maintain strong U.S. ties can now trigger removal even for green card holders. ICE enforcement is ramping up, with nationwide authority, including schools and hospitals, places once off limits now open to deeper scrutiny. Finally, let's talk about planning and response. If you're applying or your case is pending, what should you do? First, assemble a tight, well-documented application. Include everything: joint leases, bills, bank accounts, loved photos, shared travel. Anticipate the interview, prepare answers, perhaps even do a mock interview with an immigration lawyer. If your financial situation is tight, work closely with a solicitor who knows how to build a strong public charge defense. Stay on top of your case, track processing times, and consider working with an attorney if delays stack up. In extreme cases, Congresswoman or a mandamus lawsuit may be options to compel action. Lastly, remain aware of your rights. If ASIS contacts you, respond quickly. Legal counsel can help you navigate RFEs or appeals if needed. Don't wait for denial language, stay proactive. In essence, the Trump-era green card process for married couples is now far more complex and invasive than ever before. To succeed, couples must approach the process with documentation, preparation, and perseverance. This isn't just about legal paperwork, it's about protecting your future, your family, and your life together in the US.